Hi, this is Josh Blackman. I am the president of the Harlan Institute, and I'm thrilled to present the final installment of the semifinals for the 2020 Harlan Institute ConSource Virtual Supreme Court competition. Today we have two teams from Creekview High School in Texas. We have Elizabeth and Yashica, and we have Brian and Angela. Petitioners, you have 15 minutes. You can begin whenever you are ready. I think you're on mute, Elizabeth. Sorry. Elizabeth, you're on mute? Okay, I didn't start the clock yet. I'll start it over again. All right, whenever you're ready.
Good afternoon, Your Honor. May it please the court, my name is Elizabeth Adeoye.
My name is Yashica Nabar.
And we represent the petitioners, Kendra Espinoza, Jerry Anderson, and Jayden Schaefer.
A 2015 law by the Montana State Legislature created a tax credit program for taxpayers that donated to scholarship organizations that aided students to their efforts to attend private schools. This meant that the Montana Department of Revenue was responsible to give out the tax credit and make sure that the whole program was constitutional. Montana Department of Revenue found that the program was in fact not in compliance with Montana State Constitution and thereby issued Rule 1, which excluded all students wanting to attend schools that were religious from benefiting from the scholarship program. Mothers of students affected by the school, Kendra Espinoza, Jerry Anderson, and Jayden Schaefer, contended that this issuing was unconstitutional. They argued that this violates the free exercise clause. Initially, in Montana Judicial District Court, the plaintiff was granted a summary judgment on appeal in the Montana Supreme Court. The lower court's judgment was reversed. The issue brought in this court today is whether or not the free exercise clause prohibits states from invalidating a generally available and religiously neutral student aid program, simply because the program affords students the choice of attending a religious school. We argue that it does, because of 2 points we will address today. The first being that without Rule 1, the tax credit program put forth by Montana Bill 410 is constitutional. Using precedent set by Trinity Lutheran v. Comer and Zellman v. Simmons Paris, we will argue that absent Rule 1, the tax credit program does what it intended to do, help students and taxpayers justly and in compliance with the U.S. Constitution.
Well, Counselor, if I could interrupt you briefly for a minute, and Yashica, I had a little bit difficulty hearing you, so just we'll do the best we can. But I was able to hear Elizabeth okay. But let me ask this question to Elizabeth. You've mentioned a couple good free exercise cases. How do you think the Establishment Clause works in this case? Right. In other words, how does the Establishment Clause affect the outcome of this case?
The Establishment Clause, Your Honor, or the free exercise?
No, the Establishment Clause.
Well, Your Honor, the Establishment Clause affects the case of Trinity Lutheran v. Comer and Zellman v. Simmons Paris because in the Establishment Clause of the First Amendment, it states that no legislator will be able to prohibit or discriminate against anybody that wants to establish a religion.
Well, let me ask this question differently, right? Why did the Montana legislature enact Rule 1?
Well, the Montana State Legislature enacted Rule 1 because of a clause, a no aid clause in their constitution that prohibits aid to any sectarian purpose.
Right, I get that. Why did Montana add the no aid provision to its constitution, Article 10? What's the purpose behind that amendment?
Well, they added this amendment to further the separation of church and state by saying that they will not use any government aid to aid any sectarian religion.
Do you think that Article 10 of the Montana Constitution is unconstitutional?
Yes, Your Honor.
And should we declare it unconstitutional?
Yes, Your Honor. We should.
Do you know if this provision is in effect in other states?
Yes, Your Honor. Other states do have no aid clauses in their constitution.
Okay. All right, you may proceed with the argument.
The second point we will address is how Montana's no aid clauses, as applied, are unconstitutional. using precedent in Rosenberg, the rector and visitors of the University of Virginia, we will prove this.
The tax credit program was constitutional, stood before the issuance of Rule 1. Whitmer versus Vincent, a college religious organization on the University of Missouri campus, wanted to use rooms to hold their weekly meeting. But the university rejected their application for continued use based on the fact that it would violate sections of the rules and regulations of the University of Missouri. These rules did not allow use of university buildings for religious teaching. It was held that the refusal of the University of Missouri to assist religious groups on campus was unconstitutional. The reason being this petition was that the university opens its facilities in a neutral policy that any student groups would be allowed to use it. So they argued about a neutral policy towards religion would achieve an obligation that complied with its constitutional objective. This has a clear relationship to the case because the Department of Revenue will argue the issue of Rule 1 was to fix the unconstitutionality of the original document. The ideas of this case would show that the issuing of the neutral usage policy was also achieved. Argument of several sources continue to prove exactly how restricting a student's receive aid would not allow them to freely exercise their religion.
Counselor, if I could,
Madison's memorial and remonstrance against religious assessment argued for religious freedom. Madison in the majority, but also allowing Americans right to complete religious liberty. Similar to this, Thomas Jefferson wrote a series of letters to Danbury Baptist.
Counselor, if I could interrupt you for a minute. There's a lot of feedback, so it's hard to hear, but I want to make sure we get your arguments in.
Okay.
You mentioned Madison's memorial and remonstrance. Can you tell us what the memorial and remonstrance was about, please?
Yes. So essentially, James Madison, being an influential figure in our society, he argued for religious freedom in our country. So essentially, he was giving a voice to those who didn't have the voice to argue in favor of religious freedom.
Well, no, but why did Madison write it? In other words, what happened in Virginia that Madison was responding to? What were the actual facts on the ground there? Do you know?
So I'm sorry, Your Honor, I don't know.
Okay. All right, you may proceed with your argument.
So on taking this into account, similar to this, Thomas Jefferson wrote a series of letters to Danbury Baptist addressing how the acts of the whole American people, which declared the legislature should make no law respecting establishment of religion, including the free exercise thereof. By saying this, he has created a basis of how officials should create non-threatening laws on behalf of the religiously affiliated citizens. This has a great importance to the current argument, as Thomas Jefferson, an influential figure in our society, is implying that as Americans who are guaranteeing liberty to all those who inhabit the state, it only makes sense to flourish through this liberty by allowing everyone to follow whatever belief that's in the day. Men free exercise claims that have gone through the Supreme Court and historical sources about religion in our laws simply prove that restricting a student to receive would not allow them to freely exercise their religion. And Rule 1 is therefore
May interrupt for a minute?
and is in violation of the free exercise clause.
If I can ask a question of your co-counsel for a minute. Elizabeth, let me ask you a question. What exactly is the money being used for? Elizabeth, you still there?
Excuse me?
Yeah, Elizabeth, let me ask you this question. What exactly is the Stillwater Christian Academy using this money for that they're getting from the state?
Well, Stillwater Christian Academy isn't directly receiving any money from the state. In this case, the money is going to the parents who have the freedom to choose whether or not they can send their child to a religious school or a non-religious school.
Okay, but eventually Stillwater gets money, right?
Yes.
And what are they using this money on?
Well, Your Honor, it is up to Stillwater Christian Academy what they use the tuition that is being paid for. They can use it for textbooks that are teaching education, not theological education.
Can they use the money on buying Bibles, for example?
Well, if the Bibles are being used in school, then it can be assumed so. But that is not what most money in religious.
Well, no, I get most, but I mean, at some level, this money is being used for religious instruction, right?
Yes, Your Honor.
Doesn't that raise Establishment Clause concerns that the state is basically indirectly assisting the instruction of religion?
Well, Your Honor, the Establishment Clause says that they shall make no law respecting an establishment of religion. However, the aid that's being given to the students or Stillwater Christian Academy isn't directly establishing a religion. It is simply furthering the education that students may receive.
Right, but the Supreme Court has used different tests to understand the Establishment Clause. What are some of those tests the Supreme Court has used?
Could you please restate your question?
What are some of the tests the Supreme Court has used to decide when the Establishment Clause has been violated?
Your Honor, one would be in Zelman v. Harris, when the court set up a 5-prong test to test whether or not a voucher program is constitutional.
Okay, tell me about Zelman then.
Well, in Zelman v. Harris, the court set up a 5-prong test. The first point is that the program must have a valid secular purpose, which in this case is the education. The aid must go to parents, not schools, and the aid in the tax credit program goes directly to the parents. 3, a broad class of beneficiaries must be covered. In this case, there is the students across Montana can receive a quality education. 4, the program must be neutral in respect to religion, and in this case, students have the option to go to a religious private school or a non-religious private school. And 4, the program must be neutral in respect to religion. Your Honor, the tax credit program in this case is allowing students to choose what school they go to. There is no direct advantages that people that are affiliated with the religion are getting. And 5, there must be adequate non-religious options. The many private schools that are non-religious across Montana.
Well, Counselor, tell me about Locke v. Davey.
In Locke v. Davey,
Yeah, Locke v. Davey.
There was a non-tax credit program, but there was a program or a scholarship program that a student received, but he wants to use this money to pursue a theological education.
And does Locke v. Davey help or hurt your case?
Well, Your Honor, I believe that it helps my case, as in this case, the theological education that the person is trying to receive is higher education. It is not required by law. However, in this case, this is 12 education, which is mandated by law. Students must receive 12 years of education, and they would be receiving this through this religious school. Education isn't blatantly religious; it is also fundamental.
Okay. You have about 2 minutes left. You can proceed, Counselor.
I have 2 minutes left.
Yes.
Okay. So the next point that we will address is how Montana's no-aid clause was applied are unconstitutional. Montana's Department of Revenue rationale was behind issuing Rule 1 was that it was unconstitutional under their no-aid clause. And states with no-aid clauses argue that the reason they are in place is to protect the separation of church and state. But after a look at the background of these amendments, it has a history of prejudice against religion. From its inception, these amendments were put in place to discriminate against Catholics, as Catholicism was not the majority practice of religion. If this were the case with scholarships going to students that were attending a historically black college, university, or primarily white institution, the matters of discrimination would be night and day. But both racial and religious discrimination are analyzed under strict scrutiny and equal protection of it. Out of many freedoms that are protected by the United States Constitution, the ones protected by the First Amendment are among the most important ones. Infringing on these rights in any way, shape, or form is infringing on the American way of life. And through the issuing of Rule 1 and not allowing innocent citizens to reap the benefits of the American way of life, is immoral and unjust. And through the many precedent cases that have gone through the Supreme Court and the historical sources have been used in many religious constitutions to this day, it strengthens the fact that the mere restriction of the student receive aid based on the fact they want to attend a religious school is unconstitutional, unethical, and violates the free exercise clause of the First Amendment. This is reasons previously stated that we pray this court reverses the decision of the Montana Supreme Court and takes notice of the unconstitutionality in issue number 1 and goes in favor of this decision.
Okay, thank you very much. We'll now turn to the respondents. They have 15 minutes.
May it please the court, my name is Nguyen, along with my co-counsel, Brian Kang. We represent the respondent, the Montana Department of Revenue, in today's case. In 2015, the Montana legislature issued the Tax Credit for Qualified Education Contributions Act. To comply with the state constitution, the Montana Department of Revenue enacted the Blaine Amendment. The issue brought upon the court today is whether it violates the free exercise clause of the First Amendment to invalidate a generally available and religiously neutral student aid program, simply because the program affords students the choice of attending religious schools. In the case presented, the Blaine Amendment is constitutional and does not violate the First Amendment because 1. The Blaine Amendment is constitutionally permitted since it provides clarity. 2. The Blaine Amendment does not violate one's free exercise rights. And 3. The Big Sky program justifies constitutionality, along with the framers of the Constitution intending to prohibit tax money for the use of religious purposes.
To address your first point, the Blaine Amendment is constitutionally permitted because it provides clarity to what the framers intended. The Blaine Amendment by Montana states that the legislature, countries, cities, towns, school districts, and public corporations shall not make any direct or indirect appropriation of payment from any public fund or monies, or any grant of land or other property for any sectarian purposes, or to aid to any church, school, academy, seminary, college, university, or any other literary or scientific institution, controlled in the whole or in part by any church, sect, or denomination.
As stated by Thomas Jefferson, the clause against establishment of religion by law was intended to erect a wall of separation between the church and the state. Due to the fact that there are no specifications on how small or large the divide between the church and the state must or must not be, the state of Montana uses this amendment to further clarify the separation that exists between them. It is implied and assumed that there is indeed a separation that was initiated by those that belong to religious groups. And all that the state is doing is providing clear boundaries and clarifying the separation that has been created by the church.
Okay, so Counselor, if I can interrupt for a minute, do you think that, let's just pretend Article 10 didn't exist. Let's pretend we didn't have that in the Constitution of Montana. Would the scholarship program be unconstitutional under the Federal Establishment Clause?
Can you rephrase your question, Your Honor?
Is the scholarship program in Montana unconstitutional under the federal Constitution, the Federal Establishment Clause?
Well, Your Honor, because without Rule 10 or Rule 1...
I get that. Let's pretend Rule 10 didn't exist, right? Let's pretend there was no Rule 10. Would Article 10 violate the Federal Establishment Clause?
Yes, Your Honor, because that would mean that Montana would let tax money be able to be funded to those schools for religious purposes.
I'm sorry, but Counselor, I thought we have a case like Zellman versus Simmons-Harris. Tell me, why wouldn't this program be okay under Zellman?
Well, Your Honor, when looking to Zellman, though the petitioners bring up that there is the five-prong test for Zellman, when we look to the facts, we can see that Zellman deals with a voucher program, whereas today's case deals with a tax credit program. And though the court can use this five-prong test in consideration, we should rather look to precedents that have been set in many other binding Supreme Court cases that are similar, such as Reynolds, Trinity Lutheran, McCollum, and Lockby Davy.
Okay, then let's talk about Trinity Lutheran, right? What was the holding in Trinity Lutheran?
The court ultimately ruled in favor of Trinity Lutheran, Your Honor.
Okay, why?
When looking to the facts in Trinity Lutheran, we can see that the money that was being funded to them was being used for a secular and non-religious purpose. The replacing the pea gravel with the pour-in rubber surfaced.
Well, that's true. That describes the facts, but I thought Trinity Lutheran had this holding that the government can't deny funding based on an organization's religious status. Is that how you understood Trinity Lutheran?
Can you rephrase your question, Your Honor?
Oh, I didn't. I thought the holding in Trinity Lutheran was as follows: the government can't discriminate on the basis of religious status. Is that correct? Is my understanding correct?
Well, Your Honor, whenever looking to the ruling, they ultimately ruled in favor of Trinity Lutheran because the pour in rubber was for a non-religious purpose.
No, I get that, but the court also said that you can't deny benefits based on religious status. That's almost a verbatim quote. Is that right?
Your Honor, yes,
Please.
Your Honor, however, in this case, it is a tax-based program.
No, I get that. I get that, but you're not answering my question. Wasn't that the holding of Trinity Lutheran, right? That you can't discriminate on the basis of religious status. Okay. So look at the Blaine Amendment, Article 10. Isn't the Blaine Amendment discriminating on the basis of religious status?
Well, no, Your Honor, the Blaine Amendment is necessarily in this case because it clarifies the Montana Constitution, and it ultimately makes the Blaine Amendment is constitutional because it just narrowly downs the Montana Constitution.
No, I know you keep saying it clarifies it, but how is the Montana Constitution, Article 10, Section 6, how is Article 10 consistent with Trinity Lutheran? That's my question for you.
Your Honor, may you repeat your question?
How is Article 10 of the Montana Constitution consistent with Trinity Lutheran?
Well, Your Honor, Article 10 of the Montana Constitution is related to what happened in Trinity Lutheran because it just states that the legislature cannot fund places such as a church or a private domination or a sect. And without the Blaine Amendment, it would just make it unconstitutional because of the separation between church and state.
You're not answering my question. Let me try this a different way. Does the Blaine Amendment discriminate on the basis of religious status? And Angela, I think your hand up was a minute ago. If you want to join in, you're welcome to.
Your Honor, well, as to your question on whether the Blaine Amendment was... Can you repeat your question one more time?
Does the Blaine Amendment discriminate on the basis of religious status?
No, Your Honor, because what the Blaine Amendment is doing is not necessarily restricting one to freely exercise their right, because as the Free Exercise Clause allows individuals to freely exercise one's religion without interference from the state. In Trinity Lutheran, the court stated that the Free Exercise Clause prohibits the government from outlawing or restricting the exercise of religious practice, but it generally does not prohibit withholding an affirmative belief on account of religion.
All right, you may proceed. I don't think you quite answered my question, but you can proceed.
Thank you, Your Honor. As stated in Everson v. Board of Education, the amendment's purpose was not to merely strike at the official establishment of a single religion, but it was to uproot all such relationships in terms of the relationship between the church and the state.
The objective of this amendment was broader than just separating the church from the state. The amendment was created to create a complete and permanent separation of religious activities and civil authorities to prevent the prohibition of the free exercise of religion that is provided by the religion clauses of the First Amendment. The religion clause of the First Amendment prohibits the state from making laws respecting an establishment of religion or prohibiting the exercise thereof. The intention of the framers of the Constitution was to create laws that were to be neutral in relation to religious and non-religious groups. It does not require the state to be their adversary.
For the state to be able to aid those that belong to a certain religion would be to favor them over those that don't belong to one at all. State power is no more to be used as to handicap religions than it is to favor them. In Everson, the Supreme Court found that it is reasonable to help religious sects depending on the certain circumstances given to the particular case. In that case, it was agreed by all that parents might be reluctant to allow their children to attend schools where the state cut off general government services. For example, police and fire protection, public sidewalks, and highways. Cutting these basic government services makes it very difficult for the schools to operate. In our own case, the issue being brought to the court is the issue upon financial aid, which would benefit those that belong to a certain religion and leave those who are non-religious at a disadvantage. The court held that New Jersey's aid to the church in this instance is constitutional because there was no advantage or favoring of those that are devoted to a certain religion over those that are not religious.
Furthermore, in Law v. Davey, the state of Washington created a similar scholarship called the Promise Scholarship Program, with many requirements to be eligible for the scholarship. The student that is applying for the scholarship must not be majoring or pursuing a degree in devotional theology. The two programs prohibit those that are pursuing a degree in devotional theology from being given the scholarship. In doing so, the state would be subsidizing the church, which is out of their power, and leaves those who are non-religious to an economic and possibly educational disadvantage. Allowing those that are religious to get aid from the government to continue their studies and beliefs is unfair to those that are non-religious.
Moving to our second point, the Blaine Amendment does not violate the Free Exercise Clause. As stated before, the Free Exercise Clause allows individuals to freely exercise one's religion without the interference from the state. The parents contend that it is unconstitutional to invalidate a generally available and religiously neutral student aid program simply because it afforded the students the choice of attending religious schools. Though in Trinity Lutheran, the court stated that the Free Exercise Clause prohibits the government from outlawing or restricting the exercise of religious practice, but it generally does not prohibit withholding an affirmative belief on account of religion.
However, in Employment of Human Resources of Warby Smith, Nukmi Babu v. Adeoye, it further explains that the government may not devise mechanisms, overt or disguised, designed to persecute or oppress a religion or its practices. The regulations that Montana created stating that scholarships cannot be provided to students at a church, school, academy, seminary, college, university, literary, or scientific denomination prevented Big Sky from awarding scholarships to students at Christian schools, but did not oppress Christianity.
Counsel, let me ask you a question, if I can. A lot of the Blaine Amendments were enacted in the 1870s and 1880s, and the history of these are not very pretty. Senator Blaine was a bit of a racist. He didn't like immigrants very much. He didn't like Catholic people. Should the history of those amendments, the sort of racist history of those amendments, affect how we consider the current case?
No, Your Honor. Even though there is a history of that Blaine Amendment, we must look at the facts in the case and what the Blaine Amendment has effect in the case. And because the Blaine Amendment is constitutional in this case, we must not look at the history, but what effect it has on this case.
And what case tells us that? Why can't we look at the history?
Oh, Your Honor, would you repeat your...
What case are you relying on? Why shouldn't we look to history? How do you know that? Yes, Angela, your hand is up.
Well, Your Honor, because we don't have cases that are looking at the history behind those Blaine Amendments, the cases that we use today and how we're applying it to our modern society, we must look at the effect that it has had on our society. And the Blaine Amendment, therefore, is only clarifying the separation between the church and the state. And in this instance, it is trying to separate those that are religious and non-religious.
Okay, you proceed, Counsel. You have about 2 minutes left.
The Free Exercise Clause is not violated because the government still allows the parents and their students to freely exercise their religion. The government is not responsible for paying for any type of students, and just because they decided to do so because of any reason does not necessarily mean they have done an unconstitutional act. It must be the responsibility of the parents to be able to pay the funds for the school they would like to send their children to, and if they fail to do so, the fault must be on them. Additionally, the money that would go into scholarships would merely help in the group of students practicing their religion, but does not suppress their ability to practice their religion, and therefore not a violation of the Free Exercise Clause.
To address our third point, the removal of the Big Sky program justifies constitutionality. The removal of the program overall justifies its constitutionality by leveling down both the treatment of religious and non-religious groups from the government. It satisfies the First Amendment by prohibiting any advantage from either non-religious or religious groups. Leveling them down creates a fair and even level of how they are both treated by the government and the state. In the case of McCollum v. Board of Education, an atheist parent sued the board stating religious instruction in public schools was unconstitutional because it promoted religion. The court ultimately found that these religious classes were unconstitutional due to the fact that it blurred the separation between the church and the state. Additionally, as stated in Montana's No Aid Clause, they cannot financially aid any religions and not give the same benefits to non-religious groups. Using both the No Aid Clause and the reasonableness of removing the Big Sky program, the court can come to the conclusion that it justifies constitutionality. The result of the separation between the church and the state is an effect of the choices and decisions that have been made by those that belong to religious groups. Religious parents are choosing to send their children to a university or college to continue their studies, and their choices from their religious beliefs makes the circumstances and consequences different due to their intentions and decisions.
Finally, to address your fourth and final point, framers of the Constitution intended to prohibit tax money used for religious purposes. Reynolds v. U.S. held that no tax in any amount, large or small, can be levied to support any religious activities or institutions, whatever they may be called or whatever form they may adopt to teach or practice religion. Using precedents set in Reynolds, along with
Okay, Counselor, your time's up. Finish your sentence.
And Thomas Jefferson's intentions, the court can find that allowing tax money to be used for religious purposes would be unconstitutional and contradictory to precedents that have been previously set.
Okay. Thank you so much. The petitioners, you have 5 minutes for rebuttal time. You can begin whenever you're ready.
The respondents brought up many assertions in their argument, but did not provide valid reasons to support their claims. They argued that Blaine amendments provided clarity to the framers' ideas of religion in our country, but nowhere in our Constitution does it call for the separation of church and state. The religion clauses of the First Amendment were added to enumerate the rights of the people, not to provide a basis for discrimination. However, what it does state is that our supreme governing body shall not make any discrimination from the religion. The respondents even said that the framers intended for laws to be mutual in respect to religion, but the tax credit program was prior to Rule 1. Further point. The respondent brought up the point that if the state aids those that belong to a religion, it would be favoring them against those that don't. But in this case, the tax credit program was completely neutral, allowing students to choose a religious or non-religious school to attend. There was no favoritism between people affiliated with the religion and people that aren't. Next, I will address that the leveling down of the program makes religious students feel punished for practicing their religion and having the neutral financial support to do so. By making them penalized for expressing their beliefs, they are setting them at a lower status than everyone else, exclusively because they follow a certain religion, which is unconstitutional. And also, the leveling down was unconstitutional and unnecessary, as the tax credit program benefited both equally before the issuing of Rule 1. Also, the use of Locke v. Davie was misallocated, as Locke v. Davie was getting further education, but education for 12 years, K through 12, is mandated by the United States, and they are still receiving this education through religious schools.
Counselor, if I can interrupt for a minute, wasn't the issue in Locke v. Davie that they're funding religious instruction, like how to become a priest? I understand this is K through 12 education, but there's overt study of the Bible here. I mean, there's nothing preventing the money from these scholarships, right? The money from these scholarships can go to Bible studies, right? I think Locke hurts your case a little bit. Why does Locke not control your case?
Well, Locke hurts my case a bit, as they did say that they cannot fund religious institutions, but the respondents used it to say that the religious use that the money is going for is completely unconstitutional. But there's no way that we can prove that money would be spent on Bibles, and calling it unconstitutional because of this is unjust. Education is still going on at these religious schools, so simply saying they're unconstitutional because they are religious is ineffective.
Okay, may proceed, Counselor. Thank you.
Now, the Montana State Legislature is sponsoring education in the state, and by precedent set in Rosenberger v. Rector, if they do this, they must do equally. Leveling down is unnecessary, and they argue that parents choose to let their children attend private schools, but the school system in America and in Montana is failing, and they take note of this by allowing a provision of aid to go to people that want to attend private schools. But if they choose to aid in private schools, they cannot simply discriminate against religious private schools and only allow students to go to non-religious private schools, as this is blatantly unconstitutional under the free exercise law. The law is not allowing them to freely exercise their religion. It is a clear part to teach about religion through education, and not allowing each student to have their fullest opportunity to exercise this part of their religion is unconstitutional. Not only does it stop them from freely exercising their religion, but it penalizes them for doing so, which is in violation of the free exercise laws. We've argued that the thing that made the tax credit program unconstitutional is unconstitutional in itself and should not be used to stop innocent students from attending a school of their choice. And that is why we pray you rule in favor of the petition.
Okay, Counselor, thank you so much. The respondents now have 5 minutes rebuttal time. You can begin whenever you're ready. Here we go.
May it please the court, we will now be addressing rebuttal. In rebuttal, we will be addressing 2 main points. 1, the petitioner's use of the 5-pronged test from Zellman should be used as merely a reference but not as the deciding factor in today's case. And 2, it is constitutional for Montana to invalidate the religiously neutral scholarship program based on the separation of church and state listed in the First Amendment. Moving to the first point, the petitioner's use of the 5-pronged test from Zellman should be used as merely a reference but not as the deciding factor in this case. Though the test that the petitioners use is something that can be used as in consideration, we should rather look to precedents that have been set in many binding Supreme Court cases, such as Reynolds, Trinity Lutheran, McCollum, and Lockheed Davy. Due to the fact that Zellman deals specifically with a voucher program, whereas today's case is about a tax credit program, the decision and holding that the court comes to should not be based only on this one test that has been applied in one case. The petitioner also contends that there is no way of tracking whether the money will be used for religious purposes. But taking that into account, for those students to go into a major in devotional theology, it is more unreasonable for the state to need to track whether they use that for religious purposes or not.
Well, but let's talk about the tracking part, right? Does the state really need to track? Wouldn't it just be enough for the state to tell the schools you can't spend this on religious stuff, spend it on secular stuff? Isn't that what Zellman versus Simmons-Harris held they could do? Couldn't the state just give a more precise instruction how the money's spent and there's no supervision required?
Well, Your Honor, if the court were to give those specific instructions, there would still be no way of making sure that that one religion or that one religious school would not use that money for religious purposes. And because there's no way for the government to track that upon all religions, only giving it to certain schools that are given certain instruction would be unconstitutional.
All right, may proceed.
To address her second point, it is constitutional for Montana to invalidate the religiously neutral scholarship program based on the no aid clause and the separation of church and state listed in the First Amendment. The religion clause of the First Amendment further separates church and state. As stated by Thomas Jefferson, Jefferson states, believing with you that religion is a matter which lies solely between man and his God, that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state. Religion should be between man and God, and as it was stated in court today, the money that would go to religious schools may be used for Bibles or other religiously based education. The government cannot allow for scholarships to go to religious schools and would set a dangerous precedent if it is ruled in favor of the petitioner.
In the case presented, Rule 1 is constitutional, and if the court decides to rule in favor of the petitioners, it would set a dangerous precedent of blurring the separation between the church and the state. As the framers intended, the court must separate the two from each other.
It is for these reasons we pray that the court upholds the ruling of the lower court and rules in favor of the respondent.
Okay, very good. Thank you so much, Counselor. I'd like to congratulate both teams. You did fantastic, and you're operating under less than ideal circumstances. The internet connection doesn't always comply with how we want to speak, but I think you did the best you could. You've all prepared a lot, and I'm very proud of all of you. Thank you so much for your contributions. Sebastian, is there anything you'd like to add?
Yeah, this is a really, really tough case. That's why we chose it. There's a reason it's in front of the Supreme Court to begin with. That's because it's very contentious, and there's no obvious resolution to these problems. And the reason that we chose it of all the Supreme Court cases is because it's obviously even more interesting and intricate than the other cases on the docket in our eyes. So This is obviously really difficult. It's very impressive that you all are doing this at your ages and in spite of all the conditions we have right now. So great job to all.
Well, thank you so much, Sebastian. Do you have any questions for us?
Pleasure.
Anything that we can answer about the competition, about the case, about anything in general? Yes, Angela, please.
Do you guys have any like feedback for us, just like content or style wise? Just
Sure. Yeah, and let me I'm going to mute some of you because the feedback gets a little bit tricky when you're all live. So in terms of feedback, I can give a couple of broad points. When a judge is asking a question, sometimes we're asking you to take a position. I know the natural urge is to fight it. It's to resist giving a yes or no answer. And sometimes that's a good strategy, right? Because obviously I'm trying to trap you, right? I'm giving you a question to try to put you in a box. But by not answering but there's some questions where there's an easy yes or no answer, right? If I'm asking you what's the holding of this case, is this the correct holding of the case? At some point you say, yes, Your Honor, that's correct. By trying to always fight the question, you can sometimes hurt yourself. The better answer is, yes, that's the rule, but here's why our case is different. So in other words, you fight on the follow-up, but you have to agree to the initial question. Another point that's also hard for students, and it's even harder with the Zoom, is when the judge starts talking, you stop talking. In other words, the second you hear a voice, you just go, whoop, right? You stop. And that's hard live in person. It's even harder when you're sitting there on your iPhone in your bedroom, right? It's very tough to do. But that's something that you should just think about trying to do. Another point is, if there's any case that you want to discuss, make sure you know the facts of that case cold. And the reason why is a judge might ask you, how are the facts similar or different, right? What I encourage you to do is have the facts clean so you know that. Those are 3 broad points. I don't have anything specific. I think you all did a pretty good job. I don't have any specific questions you might have beyond those 3? No? Well, we're proud of all of you. This will be on YouTube later tonight. I'll be in touch with your teacher with the scores probably later this week. But I'm proud of you. If you have any questions, you can email me or Sebastian at any point. We're happy to answer your questions. All right. Thank you all so much. Have a wonderful day and good luck for the rest of the semester. Thank you.